Good morning and welcome. It is Sunday, May 24th, 2026, and this is Sunday Funday from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you all so much for being here. Mix Firebird and But Why and Cold Brew and Best Nancy, Heather Cooper Smith, Ain't No Hollaback Girl. So good to see so many familiar names and faces and some new ones too. So welcome everybody. This is going to be a good one. I'm it couldn't be more impressed with the questions that you have. Every single week, you guys have incredible questions. Court Dog Daniel is here. He says, this is the epic Sunday Fun Day before Vegas. It is. It is your last Sunday Fun Day before Crime Con in Vegas. I know somebody who's super juiced. So am I. Are you guys going to be sad? Are you going to miss all the Crime Con announcements? I feel like we've been just beating this drum for so long now, and it's finally here 1 week away, less than a week away. I'm going to be flying out there soon, in a couple days here. But don't worry, there will be another Crime Con, and then you can hear about that for another 6 months or so. All right, everybody. Hello to everybody who's watching us on Facebook and on X. Welcome. If you are watching, we would love to hear from you. Please send us a chat or a comment. Just let us know where you're from. Let me introduce myself, though, to everybody who might be new. If this is your first Sunday Fun Day, I would love to hear about that. Please let us know in the comments. But let me introduce myself to you, folks. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I was there for just over 10 years before I left to go into private practice as a criminal defense attorney. And this is Courtroom Confidential. We started this channel with the idea, the mission statement, the goal of presenting to you both sides of the courtroom, both sides of the issues, both sides of the stories. We hope that we do that. And this is a show that we call Sunday Fun Day, where we take your voice messages that you have left us throughout the week, and we're going to answer them live. And I'm trying to get to as many of them as I possibly could. If I wasn't able to get to yours, don't get discouraged. Maybe I answered your question just with somebody else's question, but you can always call back again, and we would love to hear from you. I try to spread the love as much as possible. Stay to the end. We do have announcements. Obviously, Crime Con is coming up, so we're going to have a little bit of changes to our scheduling. But in the meantime, take that deep Sunday morning cleansing breath. You've made it. It's the end of the week or a beginning of a new one. Hit that like button if you haven't already. Subscribe if you haven't already, and share this with anybody that you think might enjoy it. But let's hop into our first question of the day. Who is kicking us off?
Hi, Joshua. It's Jim from the Marshall Islands again. Hello to everybody. I have a question about the Todd Mullis. It's either an appeal or a post-conviction thingy. I know it's like a year old, but I was just watching it recently. And his claim is that he was stunned in his opening statement when his lawyer said that his wife died from murder. This is the guy who murdered his wife at the corn rake in Iowa. He said that he was absolutely stunned when his lawyer stood up and said somebody had murdered her during opening statement, because it was his understanding that they were going to argue that it was an accident. I mean, I don't believe this guy for a second. I mean, the evidence is overwhelming. But like in a different sort of case, so you're a defendant and you feel like you've decided with your attorney what your defense is going to be, and he or she stands up in opening statements and just says something completely different. I mean, can you as a defendant stand up and say, Your Honor, I'm sorry, this is not what we agreed? I mean, what can you do like in the moment? Or do you have to like wait until it's over and then file an appeal? Just curious, like what is a defendant's options when the lawyer starts doing things that they feel have not been agreed to? Thanks.
Jim from the Marshall Islands. I love that on our first flight out, we're heading all the way to the Marshall Islands. Always good to hear from you, my friend. One of my dudes calling in. The Todd Mullis case, and I know that your question isn't really about that case. Obviously, this was a wild one that a lot of people followed involving a corn rake. I'm not going to get into all the specifics of it, because I think your question is more about generally what do we do in situations where it's not just that the defense attorney and the defendant may not see eye to eye on strategy, which, by the way, does happen more often than you might think. But where the defense attorney just decides to go off the rails from the instructions of the defendant, that can present some serious problems. Just so we all understand, there are many things that are seen to be within the purview of the defense attorney. He's allowed to make certain strategic decisions, how to cross-examine people, how to admit evidence, what evidence to admit, what witnesses to call. A lot of this stuff is up to the defense attorney, because that's why you got an attorney. They know what they're doing, or should, I should say, know what they're doing. They should be the ones making most of the strategic decisions. But some things are entirely within the purview of the defendant's decision-making, whether or not the defendant testifies. As much as a defense attorney may scream and beg, they cannot keep their own client off the stand. If they want to testify, they have a constitutional right to do that, and you cannot prevent them from doing that. And that's why, if you notice, in many of these trials, they will question the defendant in open court on the record, not in front of the jury, to get them to personally waive taking the stand. They want to know that that's a personal decision being made by that defendant, because it's that important. But what else does the defendant have control over? Well, though there is not a constitutional right to a particular defense argument, you do have a constitutional right to an attorney that is working in your interests. And here's where things get a little murky. In this case, part of their appeal, I guess, is what Jim is saying, is that the defense came up and made an argument at opening statement that he thought was very different than what they had agreed upon. Defense attorney says it's a murder not committed by his client. They had discussed ahead of time that they were going to talk about it like an accident. And first of all, these are wildly different, right? We're not talking about, I'm trying to think of what might be similar. Oh, we're going to say you have an alibi, but I changed what the alibi is. This is like wildly different strategies here. I don't think that they could make an argument that constitutionally his rights were violated. But to answer your question, Jim, no, he does not. The defendant does not have to sit on their hands through that whole thing. In fact, what I would expect is at the very next break, if not in the middle of those opening statements, they should have the opportunity and should speak upon it. And there would be a full-fledged hearing. And a judge would have to make a call on, is this such a divergent failure of meeting of minds and strategy between the defendant and his own attorney that it effectively, the relationship has broken down? That while we may appoint you attorneys that you do not particularly love, we're not going to make you stay with an attorney that you simply is not working with you and is working against your interests. So would that lead to a mistrial? It could, perhaps. I mean, I'm trying to think of a situation that I've ever experienced that's similar to it, and I have not. I have had plenty of cases, not against myself, but plenty of cases as a prosecutor where the defendant is constantly complaining about his attorney and wants a different attorney, wants to represent themselves, whatever it is. And they'll have hearings, and usually those hearings end up with the judge kind of calming the person down and explaining to the defendant why the attorney is doing certain things. But, you have a constitutional right to represent yourself. Maybe that's what the judge would do. It's a wild situation. But as far as for Mr. Mullins' appeals success, I don't think waiting until after the fact during the appeal process and then trying to make this, perhaps shoehorn this into some sort of IAC argument is going to go all that far. But excellent question. Weird scenario. Thank you so much, Jim, from the Marshall Islands for bringing that up for us. And thank you, Annalie Finch, for the super sticker. We are all juiced for Sunday Funday. I'm glad to hear that. So am I. Chicago Marie, wow, thank you so much for that super chat. Very generous of you. Says, I'm bummed I will miss Crime Con. Put this all on black on the roller. Done. First thing I'll do is that for you. Therapist, you know, thank you so much. 20 on black. Okay. I like this. I like this. Maybe I'm just going to miss the whole convention and I'll be at the craps table, it sounds like. You guys are fantastic. Thank you so much for your support. We will miss you, those who couldn't make it personally. I know how difficult it is. It's not an easy undertaking to buy the plane tickets, get a hotel, take the time off, or just sometimes get out the front door. I get it. You will be missed. We will share as much with you as we possibly can. We're planning on sharing a lot of behind the scenes stuff on our members page. So stay tuned for all of that. And then again, if you can, Fox Nation is going to be streaming a lot of the events. So you can be there virtually as much as we can hopefully make that possible for all of you. But thank you guys again. All right, let's keep it rolling here.
Hi, Josh. This is Miss Garbage Brain from Galway, Ireland, and my call is less of a question and more of a moral and financial quandary I'd like you to weigh in on. Prosecutors had the option to seek the death penalty in Alec Murdaugh's first trial, but didn't pursue it. It appears that the AG is floating the idea for his retrial. I get that this is nearly a factory reset for this case, but something about this doesn't really sit right with me. This feels very much like the state of North Carolina is trying to punish both Murdaugh and the taxpayers for Becky Hill's egregious behavior. Personally, I don't think doubling down is very good optics, but what say you?
Ms. Garbage Brain. Love that. Love that name, by the way, first of all. Let's put you on the map. Galway, Ireland. So great to hear from you. I love this question. Listen, reasonable minds can disagree on this. And I actually disagree with some of my colleagues on this thing, on whether or not they can, is the first question, and should pursue the death penalty against Alec Murdaugh. And I can see reasonable arguments on both sides as well. And I'll tell you where I fall on this, but let's first break it down. Can they? Well, you heard that press conference from Alec's attorneys. Why am I blinking on their names right now? You guys know who it is. Oh, come on. It's Sunday morning and I'm still waking up. But his attorneys did this press conference. And listen, whenever Harpootlian, that's right. Dick Harpootlian and what's Griffin's first name? Jim and Poot. Harpootlian, yes. Whenever attorneys call a press conference, this isn't the press asking for it, okay? Like, don't get the idea that when these press conferences are called, that somehow the attorneys just happen to find themselves in front of a array of a bouquet of microphones and a bunch of cameras. They've called these things. It's strategic. There's a reason for it. Now, why is the next question you should ask yourself. Why are they calling this press conference? Is it to announce that they've filed a civil case against Becky Hill? Okay, sure. Do you need a press conference for that? Probably not. Or is it to do what they did in the very first question, in the opening kind of salvo? Harpootlian says, we think it's wrong. We think it's illegal for them to pursue the death penalty. That was strategic. That's to get a message out there. And he says they haven't researched the law. They don't understand this because you can't pursue the death penalty the second time around. And then the quiet part, if it's based on some sort of prosecutorial revenge or some sort of inappropriate use of prosecutorial power. So the question becomes, why are they doing it? It's not a matter of if. They could file it today. It's a matter of why may prevent them from doing it. If it looks like it's revenge, if it looks like it's intended as some sort of punishment for having exercised his constitutional rights on appeal. I fully support and applaud him appealing. Okay? I don't have a problem with that. If there was some sort of misconduct that took place with that jury, we shouldn't walk away from that as a society. I agree that this should have been overturned. I'm very frustrated by it, but I agree it should have been overturned by that misconduct from the clerk. And that is not something that we should just all kind of pack our bags and walk away from. And yes, he should have appealed and won the appeal, and fine, we're going to do it all over again. Now, they're saying it's sour grapes that they're going to pursue the death penalty. Well, the AG actually, in his own way, took to the airwaves and said, no, the reason for not pursuing the death penalty the first time around is that South Carolina happened to be in the middle of a 13-year hiatus from the death penalty. It wasn't available to them. They didn't have, they had problems and issues with obtaining the lethal injection drugs, which a lot of different states were experiencing. They simply couldn't execute it. No pun intended, but they simply couldn't carry out an execution if they wanted to. So I think a very good reason, and this will have to be, I imagine, litigated, but a very good reason why they didn't pursue it the first time around is they simply felt like this would have been Pyrrhic. Why are we doing this? Why are we doing this when we can't actually carry out this punishment? And then you start to bring up questions about resources and taxpayer money and everything else if you're just doing something symbolically. But now, since 2024, they've resumed the death penalty in South Carolina by firing squad. And by the way, they're one of the busiest states in the union in pursuing and actually carrying out executions. So it's very much on the table. Now, if they decided to do it this time around because it's available to them, to me, that's not an inappropriate reason. Harpootlian is saying, what's changed factually? Well, nothing's changed factually. He's right on that. But something has changed logistically, and that doesn't have to do with prosecutorial revenge or sour grapes. You murder, allegedly again, we're back to allegedly, you murder your wife and child over something like money or drugs, I am not losing sleep if they pursue the death penalty against you. So is it a righteous case to pursue it? I believe so. Do they have legal standing to do it? I believe so. The third part of all of this, though, is should they? And that becomes a much more gray area. Is it going to be taking up resources? Yes. Will it make things last longer? Yes, it will. Will people look at it and go, well, what are you doing with our taxpayer money? Perhaps they will. Those are all, kind of more political questions than anything. But from a legal perspective, I think they're on solid ground. Great question, Miss Garbage Brain. I don't think you got a garbage brain. I think that was a fantastic question. Best Nancy, thank you so much for the for the gifted membership. Appreciate you. Heather Coopersmith, thank you so much for the super sticker. That's very kind of you. Arizona Gal, there you are. Love this channel. In a crazy world, this community feels like a breath of fresh air. What a nice thing. Thank you for that. Thank you, CC fam. Bear down from Tucson. That's very, very kind of you. That makes me feel good. All right, let's keep it rolling here.
Hi, my name is Megan from Draper, Utah. I have a question for Josh about the Kouri Richins trial, but a little bit of a different angle than what most people talk about. I was really intrigued by the fact that her attorney is so convinced of her innocence even after everything that she's seen and everything that she's heard. And I'm curious if you've ever had an experience like that. It's been really amazing hearing your experience as a defense attorney, and like everyone else has, given me a new perspective on what that must be like. And I am curious if you've ever had a client, you don't have to give specifics, but where you've ever gotten all the way through to a conviction and still been certain of their innocence. And if you could speak a little bit to what that experience has been like. Thank you for that. And I do recognize that I live very close to the Maverick in Draper. That's been a big part of this case. And I will never look at it the same. Anyway, thank you. I love your show. Bye.
Megan from Draper, Utah. Thank you so much, Megan. That's so nice of you. Let's put Draper on the map. A lot of people had questions about this, Megan. We actually answered, I think, a couple about this last week about during the sentencing for Kouri Richins, her attorney, one of her attorneys, Wendy Lewis, got up and gave a very kind of impassioned plea for mercy and talked about her belief in her I don't want to use the word conviction, but her solid belief in her client's innocence. And that, I think she said something along the lines of, I've never represented, an innocent person like this. Okay. Some people asked, is that appropriate? Is it inappropriate? Is it vouching? Well, here's the thing. One, it's kind of a no holds barred situation when it comes to sentencing hearings. There's a lot of stuff that comes in that wouldn't come in otherwise. Is this vouching on the part of a defense attorney? Sure, but what else do you want from your attorney at that point? The woman's about to be sentenced to prison for the rest of her life. If her attorney gets up and says, Your Honor, I believe in her, I don't think anybody's going to cry foul at that whole thing. Two, whether she actually believes that or not, I don't know. I'm not going to call her a liar, but perhaps she does believe that. Perhaps she's also being clever in the way that she's characterizing it, as far as, I believe that my client is not guilty beyond a reasonable doubt, but, not giving insights into whether or not whatever private conversation she may have had with her client. The end of it is this: it doesn't matter all that much to the judge, and it shouldn't really matter all that much to us, and we shouldn't really be shocked by the situation. But to answer your question, Megan, have I ever had an experience where I've stood next to a client that I felt was innocent till the very end? And the answer is yes. And that is something that still bothers me very much so to this day. And I'm not talking about a murder case. It's not all that sexy. I'm talking about a case that involved allegations of, how do I put this simply? It was kind of like a real estate and securities fraud case. Okay. Kind of real esoteric, in the weeds paper stuff. But I fully felt convinced that what they were calling crimes was simply people who had invested in a product that was far more volatile and risky than they had realized. I believed fully that this is like saying you buy a bunch of Apple stock and Apple goes bankrupt. You don't go after Apple and say you stole my money. You go, I made a bad investment. And that was my firm belief to this day of what my client had done. If he had done anything wrong, is he had simply represented people in buying a product which didn't go well for them. And these people lost money, but instead of viewing that as I invested in something risky, they viewed it as your client stole my money. And I felt that the government was completely off on the way that they characterized it. And it was one of the most frustrating experiences of my career. I really struggled with this a lot because it was, I think, something where people just simply didn't understand it to the way that I did. And I will not be convinced otherwise. And he got convicted and he went off to prison, and it bothers me a lot. And so, yes, are there situations where you're standing next to somebody that you're fully convinced their innocence. Yeah, it happens. It happens sometimes. Listen, I've stood next to plenty of people where I fought like hell and they got convicted, and I realized, listen, that a lot of their own troubles are from their own making. But this was one where I just felt like it was a miscarriage of justice. So great question. Megan, appreciate you. Thank you so much for calling in. All right. Shall we keep it rolling? We shall.
Hi, Josh and crew. This is Curious Kim from Inwood, West Virginia. My question this week is about the Murdaugh retrial. Is there any scenario where the government could hold Becky Hill financially responsible for the cost of the retrial? I know a lot of times governments won't re-prosecute because of the cost associated. And knowing that he's going to spend the rest of his life behind bars anyways for the financial crimes, I would hate to see that this is a decision they might come to. It seems that Becky Hill did not have nearly enough consequence for her action. And while that's just my opinion, she did financially get rewarded in a sense with her book and any sales that it has. So if she was allowed to benefit from her tampering, why shouldn't she be responsible for the consequence of her tampering? Just curious if there is any scenario where that might ever make sense. Hope you're having a great day. Look forward to hearing an answer.
Curious Kim from Inwood, West Virginia. Let's put you on the map, first of all. Thank you so much, Kim, for calling in. Great question. Listen, first of all, if this comes down to a shared frustration for what Becky Hill has done in this case, I am right there with you. I do not buy the whole, oh, she kind of got, caught up in the flashing lights and all the attention and, in over her head. This lady knew better. And in a case of this seriousness and magnitude, to do what she did is just really unacceptable to me. And because it really tears at the core of our criminal justice system, something that I have dedicated my life to, taken an oath to uphold, and for this person to undermine it really bothers me fundamentally. The other thing I'll say is, I know a lot of you are asking, or at least a couple, and I think we've got a couple more questions, are asking about resources and taxpayer money and things like that. I'll be honest with you, it is not as big a part in the decision matrix as you might think when it comes to these counties. A lot of it is viewed as, listen, you clock in and you clock out every single day when you're working for the government anyways. If you're working on one case or another case, you're going to be there anyways. It's not like it's not the same as, hiring a private attorney. Alec Murdaugh, I understand they're doing it pro bono, but under normal circumstances would have to pay for a whole new trial with other attorneys. That is expended resources. The DA's office is going to be there working regardless. Now you could say, well, yeah, but they're pouring so much money. They are, but they aren't. I mean, it's not like the salaries of the DAs go up. It's not like the salaries of the investigators go up. They're putting on a trial. Is it a trial that's going to take a lot of time? Sure. But yes, there is a consideration for it, but I don't feel it is as much as you all might think, as far as like, are we going to spend this money? Now, from a political perspective, for the DA as an elected official, or in this case, the AG, are they concerned about how the public might view it? Yes, perhaps. But I also think they realize that the public is very much interested in justice in this case. Now, are they going to go after her for money? Short answer, no. Making that civil case work, I think, is just too many curlicues along the way. She is getting sued by Murdaugh, so she'll have to pay some money for that. But as far as like the people of the state of South Carolina somehow squeezing some juice out of her for the harm that they've caused to that county, not really going to happen. She did make some money. You're right. She admitted under oath that she made about $100,000, I think, as an advance on her book. But even the sales on that were halted due to plagiarism allegations. So perhaps they've even come after the people that gave her that money, may have even come after her for that money. I don't know if that was actually sales or not, but you know, she's not living on some private island somewhere. But great question, Kim from Inwood, West Virginia. Appreciate you asking that. All right. I know it's something a lot of people have been curious about. Cheryl, thank you so much for the super chat. Says, I hope you all have an awesome time at CrimeCon. Wish I could go. Next time, Cheryl, don't worry. You know what's great about CrimeCon too is it moves around the country. So maybe the geography will be more convenient for some of you all next time. All right. Venus Blue Cupcake says, if you were Tyler Robinson, would you ask for a new lawyer after what his lawyer said about Kouri? Would you feel safe with her as your lawyer after that? I think where Venus Blue Cupcake, love that title, by the way, is coming from is that Wendy Lewis, in her comments about Kouri, said that it was her only innocent client. And I'm sure a lot of her clients went, huh? First of all, I don't know if Wendy Lewis is on the defense team for Tyler Robinson. I think it's just Kathy Nestor. So I don't believe they're in the same firm. I think she was just kind of brought on as another attorney for that case. I don't think Wendy Lewis is part of the team. But again, I think a lot of this is kind of puffery, as we would call it in the legal world, on the part of Wendy Lewis's part. And I don't know if anybody took her all that seriously. Oh, they are in the same firm. Oh, well, maybe they're in the same firm. I don't know. You know, I think Tyler Robinson should have no complaints right now with the representation that they're giving him, because it seems like they're doing nothing but causing a bunch of trouble in that court. So there you go. Becky says they're just Nestor, but Lewis is a partner in that same law firm. So, which means she's considered, you know, he's hired by he has retained the firm. You don't get to split hairs that thin. If you've hired an attorney out of a firm, you're seen as being represented by that firm. Lulu loves Radiohead. So good to hear from you. Thank you so much for the super sticker. That's very kind of you. Appreciate that. All right, here we go. Tiff says, can we get to 700 likes for a gifted membership? I think we can. What are we at? I can't see on my screen. You'll have to tell me so I know how excited I can get about the whole thing. 350? 350. You want us to double our likes? She's already in a Vegas mood, everybody. All right. Hush up, Ritter. Get on to the next one. Here we go.
Hi, Josh. Eric Hoover here from Unionville, Missouri, north central in the state, up by the Iowa line. I have a question, obviously, and that is, when defendants are in trial, I notice that they keep writing things down on a notepad or paper. What is it that they're writing, and who gets to see that? I'm about 80% juiced. Wish I could be at CrimeCon. Have a great time. Bye.
80%. Eric, one of my dudes, first of all, from Unionville, Missouri. So good to hear from you, my friend. 80%. 20% drop off in juicery just because you're not making it to CrimeCon. I understand, but we got to get those numbers up, my friend. What do defendants take notes about? You would be surprised. I've had defendants who take copious notes, and they are paying attention to everything that's being said, and they're writing down everything that's being said. I've had clients who never pick up their pen. and seem tuned out during the entire thing. I've had ones that love to write me little notes and then hand them over to me, which absolutely drive me nuts. I've had ones that if the notes don't work, then they're in my ear constantly trying to give me advice or telling me what to do, which drives me even more nuts. I once had a client, it was a young kid, and he wouldn't shut up. He was in my ear the entire time. We were doing his preliminary hearing. It wasn't a serious case. It was like a drug-related case, marijuana kind of case. And he's in my ear and this and that. And, you know, that's wrong. That's not, I didn't do that. That's, and there's no jury present. And finally, at one point, I just turned to him and I'm like, if you don't shut up, I'm walking out of here. Can you please keep it zipped for just a minute and let me pay attention to what I'm doing here? I think that shut him up for about 5 minutes before he couldn't control himself again. But the answer is there's no one thing that they're doing. But to your other question, which is interesting, is does anybody ever get to see them? Well, first of all, no, for the most part. That is considered attorney or considered work product, even though it's not the attorney doing it. It's the defense team. It's work product. So no, that's never going to be turned over. Second part of that is an attorney's is going to fight like hell to make sure it's never turned over under any circumstance. But here's a circumstance where it could be a problem. If that defendant decides to testify and then foolishly takes their notes with them and is referring to them or using them to refresh their memory, then yeah, you're allowed to take a look at it. Anything that the witness uses to refresh their memory is allowed to be seen by the other side. That's a hard rule. So if they're up there with their own notes, and I've had situations where somebody thinks it's clever for them to have brought some notes with them and start referring to them, and I'll let them do it. And then I'll go, Your Honor, they're referring to notes. I'd like a copy. Oh my God, everybody loses their minds. But yeah, you're entitled to have that stuff. You're entitled to see what they're referring to. If you got a client and he's taking notes, just make sure he doesn't take them up on the stand. But great question, Eric from Unionville, Missouri. One of my dudes. Appreciate that, my friend. All right, let's keep it rolling. I feel like I'm already losing my breath. Calm down, Ritter. I'm pre-CrimeCon excited, everybody.
Hey, Josh, this is Wally from Rio Rancho, New Mexico. Just have a question for you regarding Mackenzie Shirilla, the new documentary of the crash on Netflix. Me and my wife watched it recently, and we both came to the same conclusion where we kind of feel like charging her with 2 counts of murder was a bit excessive. Don't get me wrong, I do think that she does deserve jail time. However, 2 counts of murder seems a bit excessive in our opinion. Maybe vehicular homicide would have been more appropriate, but I don't know. That's just my thoughts. Just want to know what your thoughts were. Love the show. Keep up the great work.
Wally. Whoa. Wally from Rio Rancho, you are our first caller from New Mexico. Is that right? We've never had a caller from the state of New Mexico before. What have I done to the good people of New Mexico that they have waited this long? Well, I'm so glad that we've done. Is this every state now? Did we get Alaska? Oh, look at that. The Dakotas don't like us. Look at that big old gap right in the middle there. We got to get the Dakotas on the map. What is that? What's that down there? Zoom in. I should know geography. All right. Whoever lives in that area, tell your friends. Somebody make a phone call that we need to put those on the map. But I love this. New Mexico for the first time. And one of my dudes. A lot of dudes calling in this week. I like it. Wally from Rio Rancho, thank you so much, my friend. And great question. Unfortunately, I have not watched The Crash yet. And I know everybody's going wild over this documentary. I've heard a lot about it. I've heard it's very good. I've seen some clips online. I know that her father kind of says or does some things that some people are pulling their hair out about. We want to watch it. We keep talking about watching it. It's just I've been so busy. I've been, on planes and back and forth and exhausted. And then by the time we get down to, do you want to watch anything? We're both falling asleep at night. We're going to watch it. It's on our playlist. We're going to watch it, but we haven't watched it. I even meant to watch it last night. We both passed out. Just in anticipation of this question, but I failed. I have failed you, Wally from Rio Rancho. And so I apologize, but I do know enough, I think, about this case to weigh in on your question. And again, this is one of those things where I could understand people disagreeing about this. I could understand people viewing this different ways. You do have a troubled young person here who does something probably not fully realizing the consequences of their actions. What we're talking about is Mackenzie Shirilla, who back in July of 2022 in Strongsville, Ohio, she's got her boyfriend, Dominic Russo, and their friend, Davion Flanagan, both in the car. And she decides that she's apparently made attempts at taking her own life before. She's feeling like, for whatever reason, she has to end it all. And she has to end it all with her boyfriend and their friend in the car as well. And going over 100 miles per hour, slams her vehicle into a brick wall, killing Dominic and Davion, but she survives, of course. There's the vehicle. How anybody walked away from that, survived that, is amazing to me. Now, you're not alone. I've heard others suggest that maybe something less than murder. You suggested vehicular homicide. I'll just go ahead and say up front, vehicular homicide would likely get her the same amount of jail time that she's already received. I mean, a vehicular homicide is just another way of getting to a murder. Really, though, I think the question that we should be asking, the law, remember, is concerned with what a person did, the actus reus, but far more concerned with what a person was thinking when they did it, their mens rea. What was her intent at that time? What is the intent of a person going 100 miles per hour and slamming their car directly into a brick wall? Is that intending to take another person's life? I think so. I think clearly so. Is that intending to take her own life? Yes. But that doesn't negate or absolve the lives that she did take. And I don't think there should be much question or quarrel about whether or not she intended to take their lives. Sure, if she intended to take their lives, now we're dealing with murder. We could set the degree. We could say, okay, was she under great emotional distress? Was she in the heat of the moment? Was it premeditated? We've talked about this before too. How long does it take to actually premeditate something? Doesn't need to be long. Could be a matter of moments. I mean, we talk about that whole example of the traffic light. When you're approaching a traffic light and it goes from green to yellow, you make a decision. You make a premeditated decision. Are you going to go through that intersection or are you going to stop short? Are you late for something or do you have time? Do you care about the safety of the people inside of your vehicle or not so much and you're going through that yellow light? Do you know how long that yellow light usually lasts because you've been there before? All of these calculations, as much as they are, can take place in a matter of seconds, and they do, and people make decisions in a matter of moments. And I think just having known how I think she circled back around, how far she drove that vehicle going 100 miles an hour, how you have to keep your foot on the gas, all of this in my view, as somebody who knew exactly what they were doing. Premeditated that. Is that murder? In my view, it is. Call it vehicular homicide, whatever you want to call it. But what it's not, and I think what you were kind of going for, Wally, and I'm not saying you're wrong to think this. I'm just saying I believe differently about it, as I don't think it's manslaughter. Manslaughter would be some sort of negligence. She was driving too fast because she was trying to pass other vehicles, but she had no intent to do harm to anyone. She was driving too fast and driving erratically because they got the music playing and they were all screaming at each other and they were having a good time or whatever it is. That's negligence. That's disregard for others. But when you start to get into the idea of premeditation and intentionally driving your vehicle and intentionally speeding and intentionally a disregard for the health and safety of others, to me, you've stepped into the area of murder. And I think what she was convicted for is what she should have been convicted for. But I will do you this, Wally. I promise you I will watch that documentary. And if I feel differently about it, I will let you know, especially because I expect you to now head up the Courtroom Confidential fan club in New Mexico, considering that you are our only member so far. All right, my friend. Thank you so much. Heather Cooper Smith, thank you for the super sticker. That's very kind of you. Nate Dog, thank you for the super sticker. Good to see you, my friend. Court Dog Daniel, a lot of dogs in the house. Attempting to influence a juror, I guess that's South Carolina Code 16-9350, is a misdemeanor, punishable by up to 6 months in jail. Becky Hill should get the 6. You got no quarrel with me. I don't know why she wasn't charged with this. Do I think she should have done jail time? I do. I know that a lot of people, we were even talking with Julia Janae. She was on our show not too long ago. And she said, well, she has been punished a lot. She's lost her job, lost some money. She suffered a criminal conviction. She's, reputationally, she's a pariah. I get all that, but you also put your finger on the scales of justice. And to me, an example should be made. And if that's 6 months in jail, so be it. Tell you what, if Becky Hill went to trial for this crime, I guarantee you she wouldn't want a clerk like Becky Hill in her own courtroom. Go ahead and do it. Bring the charges, Court Dog Daniel. Thank you for that. All right. Where am I here? I feel like I'm getting lost in the weeds a lot. All right, here we go.
Hi, Josh. This is Ashley calling from Clearwater, Florida. I have a couple of questions for you this week. First, I was wondering if you can explain how a defendant who is found not guilty in a criminal trial is found liable in a civil trial. I'm specifically thinking of OJ. We all know that he was guilty criminally, but setting that aside, if a defendant is found not guilty in a criminal trial, how can they be found liable in a civil trial? My second question pertains to the baby bar exam. My understanding is that this is something that only California has, and that really it should be used by people who are court clerks or paralegals or have some kind of law background, but they're not necessarily attorneys. We've heard a lot about this from Kim Kardashian, and I was just wondering, how do attorneys, or specifically you, feel about somebody like Kim, who has zero legal background or training and certainly did not go to law school? How do you feel about people like her trying to circumvent the system to become an attorney without really paying their dues? And then my final question is regarding jurors. When they have to review disturbing evidence, photos, videos, transcripts, recordings, are they provided any kind of counseling or assistance at the conclusion of a trial? Thank you so much. Have a great day.
Ashley from Clearwater, Florida. Thank you so much, Ashley. I love the efficient use of your time there, getting 3 good questions in. First, to your last question. Jurors who view incredibly disturbing evidence, photographs, testimony, audio, hear about horrible things, videotape. Short answer, no. They don't get anything. They don't get any kind of counseling whatsoever. There are, in certain counties that have the resources, victims advocates that I think sometimes will provide some outreach to jurors, but no. If you think that these counties have the budgets to, be giving out free therapy to people who've been through this, no, they don't. And it's unfortunate. I get it. This is not the first time I've heard that question. People are like, listen, we're asking a lot of these people. We don't even pay these people. They're taking time off from work, and then we're putting them sometimes through some horrific circumstances. Yeah, we are. It is a big undertaking. It is we talk about it as your civil duty and your civil service. It is an undertaking, though. And the courts and judges and attorneys are very appreciative of that, but they don't really have the ability for, how to help these people deal with that after the fact. And by the way, I've been a part of cases which are incredibly disturbing and seen the toll that is taken emotionally on some of these jurors. Great question, though. And I've heard that before. All right, let's get to why can a person be found not guilty criminally, but then found liable civilly? And the short answer is it's a different standard of proof. It's a vastly different standard of proof, by the way. The highest burden of proof that we have is in a criminal case, and that's beyond a reasonable doubt. There is no higher burden of proof. There are levels below that. There's clear and convincing evidence and things like that. But beyond a reasonable doubt is the highest standard of proof, burden of proof, I should say. Civilly, it's our lowest burden of proof. It's as low as you can get, called preponderance of the evidence, meaning when I say as low as you can get where one side is still winning over the other, meaning that's all it is that you believe it is more likely than not. And even slightly more likely than not is preponderance. So that's why it's a whole different ballgame. Not to mention that certain evidence that can be allowed in a civil case, you're not going to get in a criminal case. You can depose the defendant in a civil case. You can't do that in a criminal case. So you're talking entirely different sports, and comparing the two is not helpful to understanding why there's a difference. But that's the main difference, is that burden of proof. And you will see this happen often. Yeah. In OJ, other cases, I'm trying to think of another good one that's a good example, but it happens often, but not as often as you think, because it's rare that a criminal defendant will also have money. So when you got those circumstances, that's when you'll see it. All right, let's get to your third question, which is about the baby bar. Kim Kardashian and the baby bar. I don't know if other states do this. I know that other states have ways that you can become an attorney, a member of the bar, without going through law school. I think certain states have these types of apprentice programs, but don't think of it as that's all you got to do to become an attorney. What the baby bar is it's a test that people who either go to unaccredited law schools or are taking part in some approved apprenticeship program, they have to take this test after their first year. So there are plenty of law schools in California that are not accredited. They're just smaller. City there, you'd be surprised. There's a lot of just kind of like West LA School of Law. After your first year, you have to take this bar. It's a 1-day exam that kind of tests you on your general knowledge of what you should have learned in your first year of law school. So kind of like criminal procedure, civil procedure, evidence, criminal law, things like that. And it's just to kind of vet and make sure that those folks are still on track. And if they don't pass it, they have to start all over again. But just because you pass the baby bar doesn't mean you've passed the bar. They then have to complete their 3 or 4 years of law school and then still sit for the statewide California bar. So they still have to go through the same process, but they have to do this additional step. So I don't know what's going on with Kim Kardashian. You'd be shocked to know that I don't follow her all that much. She has not been able to pass the baby bar. Is that what's going on? I know she failed the bar. I thought it was the bar, not the baby bar. I would ask you guys to keep me updated on that, but I'll be honest with you. I don't know how interested I am. I will say this though, just to get in my last little jab. The bar now in California is 2 days long. It used to be 3. I don't know why we're making it easier for people to become lawyers. If you've seen lawyers out there, I don't think we need more of them. All right. Let's keep it rolling here, shall we? Oh, thank you so much, first of all, Peachy Keen, for the gifted membership. That's very kind of you. Beth Ringle, thank you so much for gifting the mods coffees. That's very kind of you. And Julie from Switzerland, enjoying the show. Love, greetings from Switzerland. I love that. Thank you so much, Julie. And thank you to David Abe for becoming a YouTube member. Wait a minute. Do I know this person? Oh, I love it. Thank you, David. Thank you, David Abe. That's very sweet. That's very kind. All right, let's keep it rolling here.
Hi, Josh. This is Gloria from Florida, Tampa area. My husband and I are watching your Monday night show with Alex Murdaugh suing Becky Hill, and we're wondering how does any incarcerated person sue anybody? That's our question. And then we wondered, is he giving his power of attorney over to his attorneys, Harpootlian and Griffin, or how does that exactly work? It's a very interesting situation. All right. Thank you. Bye.
Gloria from Tampa, Florida. Thank you so much, Gloria. Let's put you on the map. Listen, incarcerated people are allowed to file lawsuits just like anybody else. They lose a lot of rights, the chief amongst those being the right to freedom. But they don't lose their ability to sue. In fact, you'd be surprised. Sometimes inmates are some of the most litigious people around, constantly suing the prison system, constantly suing their jailers. There's a lot of litigation that comes out of prisons. They got whatever grievance they've got this week. They got hurt. They didn't get served the proper diet that they requested. They're not getting the proper medical care. A lot of lawsuits. Not a lot of attorneys representing them in those things, because a lot of it is just kind of frivolous nonsense. But yeah, they're allowed to sue. There's nothing preventing him from doing it. And listen, I feel it. The audacity of it should not be lost on all of us, that this man is suing anybody for anything. By the way, one thing that didn't get overturned in all of this for Alec Murdaugh is he's still a convicted felon for stealing millions of dollars from his clients. So for him to all of a sudden turn around and be this aggrieved victim is a bit of a little difficult for me to swallow, but doesn't mean he doesn't have solid footing. I think he's actually got solid footing as far as a violation of his constitutional rights by Becky Hill. He's got a pretty good case. He probably will win, by the way. But don't get too disheartened about it, because whatever money he gets, I'm sure will be gobbled up by the restitution that he owes to all the people that he stole money from. And no, power of attorney. I know you were asking about that. Power of attorney just has to do a lot with giving your attorneys to sign and take over, things that might need your personal signature. He probably doesn't have power of attorney with them. He probably does need to sign a lot of documents. They are his attorneys and they're acting on his behalf. And I understand they're the ones even bringing this lawsuit. Again, they are saying that they're not going to get a dime out of all of this. A lot of free legal services going his way as well, which is funny to me. Anyhow, thank you, Gloria from Tampa, for asking that question. We appreciate you and appreciate hearing from you. David and Kelly are super juiced for can I say? Am I allowed to say? All right, everybody. This is one of our biggest fans and a person that we are a big fan of. This is Kaylin's dad, David Abe, who we are big fans of, and he's big fans of us and big fans of. He should be big fan of his daughter because we are as well. So thank you so much for all that support. And we're excited about CrimeCon too. It's going to be fun. Shy Gal, thank you so much. Says, please hit the like button. We appreciate all of you so much. Thank you, Shy Gal. Ann Potter says, love our Sunday Fun Day from just outside the Oh boy. Are you down in Garden Grove, Ann? Good Lord. Have you guys followed what's going on with that? I read this morning too, I watched something this morning saying they don't believe that they've got it any closer to being contained than it was when they first did the evacuations. This is wild. There's a chemical leak from I think it's a like a jet fuel factory or something. It's not a gas refinery, but there's a chemical tank that is in some sort of distress. I don't know if it's leaking just yet, but they believe that it's an explosion danger out of Garden Grove, which is in Orange County here in California. And they've had to evacuate people who, by the way, the homes are right up against this facility, some of the neighborhood there. And they've had to evacuate, I think it's a mile circumference area to get people out of there. Not because they're worried about like, chemical fallout. They're worried about explosions. Like this could go horrible, and it could destroy that a mile circumference area. They're saying damage. It's a plastics factory. It's absolutely terrifying. Then I read that there's the explosion, but then there's the chemical cloud danger after that, which extends for miles. 50,000 people evacuated. It is terrifying and wild. And so Anne, very close, 2 miles away, not even close to containment. Wow. Anne, I hope you're safe. I hope you're well. Thank you for checking in with us. Anybody else who's living down there, I hope you're safe and well. Wild stuff. And my understanding too is they're not even close to containment, and they don't know when containment will take place. I also read that they are trying to do their best to remove or empty the tanks surrounding this problematic tank in case they don't want some sort of chain reaction. And do we know what caused all of this? I still don't know if we've read about that. I apologize that I've not been in the weeds on this one. I've been back and forth on airplanes, but it will either leak or explode. Oh, there you go. And then I think the leak is what they're hoping for, because they're hoping for it to just kind of leak, empty, and drain harmlessly rather than explode. I think they know what exactly is causing. I don't think they know exactly what's causing it. Crazy stuff. Well, thank you, Anne. Yeah, Knott's Berry Farm, Disney's in that area, but they've told us that it's pretty they're safe, those areas. Yeah, stay safe, Anne. Wow. All right, where am I here? We just talked about okay, now I see where we're at. All right. Not my fault.
Hi, Josh. This is Pam calling from Michigan. Actually, I should say I'm calling from St. Clair, Michigan, a little town across the river from Canada, just south of the Blue Water Bridge. I have a question about Becky Hill. I know that she's on probation for what she did. So she does have, that criminal case or I'm not sure. I think that was a criminal case against her. But now that Alex Murdaugh is wanting to sue her civilly, is that double jeopardy? Can they go after her in court if they want to bring her in and depose her as a witness and say that she did all these things? Like, wouldn't that be a double jeopardy thing, or is that within their right to do that in the next court case for Alex Murdaugh? Anyway, just thought I'd, ask that question. Wasn't sure if that had been asked before. Hope you're having a great day. Can't wait till Sunday. Talk soon. Bye.
Pam from St. Clair, Michigan. Thank you for the specifics on your location. We're going to put you on the map. Pam, appreciate hearing from you. Always appreciate hearing from you. Again, I know a lot of you guys are curious about this Becky Hill thing. What's going to happen to her? So, to quickly and most directly answer your question, no, it is not a double jeopardy concern at all. We're talking about she was convicted criminally. Now they're suing her civilly. And we talked about that before. It happens all the time and there's nothing preventing it. And in fact, you can be sued civilly more than once, which does happen quite often. People sue and then they appeal and they go back and sue again. And it's a much, the only constitutional protections from being put twice in jeopardy deal with criminally and the government. A lot of what the Constitution is about, in fact, pretty much all of it, is about the government's actions. What can the government do? Can the government search you? Fourth Amendment rights. Can the government get you to ask questions? Fifth Amendment rights. Can the government put you in double jeopardy? These are not about private institutions or private parties. So bear that all in mind when we're asking questions about things. Is when you're being sued civilly, it's not the government doing it. So they can go after you. They can ask you questions. They can depose you. They can do a lot of stuff that you don't have the same protections against because it's not the government acting. Anyhow, stay on track, Ritter. Becky Hill. She has been convicted, though, for obstruction, perjury, misconduct in office. But those convictions criminally are not going to have any effect on this lawsuit. And yes, they will depose her, I imagine. They're going to send her all sorts of interrogatories, requests for admission, all the good discovery stuff that you see in civil cases that you don't see in criminal cases. While I'm thinking of it too, I think it was Court Dog Daniel that proposed that law that she violated that exposes her to jail time. They probably can't even bring those charges at this point because she's already been convicted for obstruction, perjury, and misconduct. And there is a issue. I believe it's called a Kellett issue, where if you've convicted somebody for a crime related to certain conduct, you don't get to go back and then try to convict them for a different crime related to that same conduct. You kind of have to go after everything all at once. Otherwise, that protects that person because of double jeopardy from having to answer for that same conduct again, but under a different crime. So she's probably done as far as the criminal courts are concerned. Great question, though, Pam. Appreciate you calling in. Always good to hear from you. All right, let's keep it rolling here.
Hi, Josh. Hi, Tiff. Hi, Mods. Caitlin, CC crew. It's Little Miss Red Velvet from Manchester. I want to talk about the Luigi Mangione and the lawyers with their delay tactics. And now they're asking for an evidentiary hearing over what the prosecutor said about the bullet not matching the gun in the media. What are the media restrictions on trials for the lawyers? Is it unusual for a prosecutor to be a witness? Typical timeline from charges to indictment to trial. How long is that? Talking about the jury maybe being tainted, wouldn't they be anyway, as this is a trial that's attracted worldwide attention? And wouldn't that come into jury questioning during the voir dire and the jury selection? You guys over in the States are really lucky to have so many trials televised, as the none are here. And Josh, I am learning so much about the law I'm even answering the questions now. See you Sunday. Bye.
LMRV from Manchester, England. Let's put you on the map. Always great to hear from you. Oh, it's me, she says. Yes, it is you. Thank you so much for calling in. One thing I'm going to say, Little Miss Red Velvet, is you asked about Luigi Mangione, but I think you meant Tyler Robinson. But I forgive you because I know you've got a lot going on. But yes, Tyler Robinson is the one where they're asking for sanctions against the prosecution because of statements that they made to the media regarding a bullet. Okay, let's unwind this whole thing. If you remember, a couple of weeks ago, the ATF released a report regarding the ballistics testing done in this case. A bullet fragment had been recovered that had been the bullet that killed Charlie Kirk. That bullet was damaged to the extent that they could not match that bullet to the rifle that they recovered from Tyler Robinson. Now, the media took this up. Some of the media, I should say, took this up. And I think in a very, at best, lazy and sloppy, and at worst, flat out misrepresentation of the findings as exculpatory evidence to try to create the salacious idea that Tyler Robinson, his gun doesn't match the bullet. Where this came from was in a reference in a motion from the defense. So that report hasn't actually been released to the public, but the defense referenced the report. And they did. They characterized it in a way that was less than clear. It did have you could misread it as if to say that the bullet didn't match, but that's not what the ATF report was saying. The ATF report was saying that it was inconclusive. In other words, it could not be matched because of the condition of the bullet, but nor could it exclude the rifle, which is far more important. Had their report said we can exclude the suspect rifle as being the rifle that fired that bullet, then you're talking about huge news and a problem. That's not what was being said. Ballistics matching on bullets is not as specific a science as something like DNA. Okay. My good friend Matt Murphy gives the example of you can pull a fingerprint from a wine glass easily, but if that wine glass is shattered and you're trying to piece it back together to pull that fingerprint from it, you might not be able to make a match. It might be inconclusive, but you might have enough of that fingerprint on the fragments of that glass to exclude other fingerprints, right? And that's all that happened here. They were not able to exclude the rifle, but they also were not able to say that it was, in fact, a match to that rifle, so it's inconclusive. Okay. That report, that statement is made by the defense in a motion. The media runs wild with it, some of the media. And the prosecution then commented to the media saying, no, that's not what this ATF report is saying. Basically saying what I just explained. The defense then, in, I think, a full-fledged irony, turn around and pounce on the prosecution and say, you spoke to the media in violation of the gag order, therefore we want sanctions against you. Now, most judges would hear all of this and say, there is a gag order in place. I don't want you speaking to the media. Next time there is an issue like this, bring it up in court. But I don't find that there's a violation here of the gag order because it's not intended to influence the public. It was simply correcting the record. That's the way I think a reasonable judge would view this. But this judge is going to have a full-fledged evidentiary hearing about it, because that is what he likes to do, is have full-fledged evidentiary hearings about everything. And while I think that this judge has made the right decisions eventually, the time and court resources that he takes in getting to them is staggering to me. So instead of just hearing the arguments from both sides, he's going to have an evidentiary hearing where he's going to allow the defense to call members of the prosecution to the stand to testify about internal conversations they had on what they would say to the media and who would comment on this issue or not. It's just a wild waste of time. And maybe at the end of the day, he'll arrive at the decision that I say that I think is right. I think to sanction the prosecution for this would be pretty outrageous. But just the amount of time that we're taking for everything, and the defense knows it, and they're running with it. They are the epitome of give them an inch and take a mile. And they are taking every opportunity to have hearings on every possible issue in this case. And we have not discussed piece of evidence number one. The only thing I will say is that in spite of all of this, the judge has not moved the prelim again, and we are still set for July. So we're coming back on the 12th of June for this evidentiary hearing, but the prelim is still set for July. Thank you, Little Miss Red Velvet. I'm just so exhausted with this one at this point. The case is interesting. It's an important issue. It's an important case, but this judge is just starting to really drive me bonkers. All right. HMS Gen X lady. Sounds like a ship. Thank you so much for the super sticker. Says, I appreciate your perspectives, Josh. Wishing you a great time at CrimeCon. Thank you so much. That's very kind of you. Heather Cooper Smith, thank you so much for the super sticker. That's very kind of you. And Ida Van Schlockwick. I'm going to just say I nailed that on the first try. Thank you so much for the super sticker as well. Very kind of you. All right. Where are we at here?
Hi, Josh and Tiff and Mods and CC crew. This is Oh My Tosh calling in from Dublin, Ireland. And my questions this week are about Luigi Mangione. First of all, why is Luigi Mangione being charged in 2 jurisdictions, on state and federal? Is this normal for someone to be charged in more than 1 jurisdiction? What exactly are the charges, and could this potentially be double jeopardy? Yeah, I'm just a little bit confused with what's going on there. So yeah, I hope you can answer my question, and I hope to hear you on Sunday. And bye.
Oh My Tosh from Dublin, Ireland. It's funny because Tiffany and I sometimes call ourselves that. Team Tosh. Josh, Tiffany and Josh, Team Tosh. Oh My Tosh from Dublin, Ireland. Good to hear from you. Thank you so much for calling in. Talking about Luigi Mangione. Yeah, we've talked about this before, and I'm sure people are still curious about it. How is it that he's allowed to be charged twice for the same thing? I thought you in the States had a thing called double jeopardy. Why isn't that happening here? Well, we do have a thing called double jeopardy, but we've also got a thing called a federal and state system. So we have the federal government, which is the United States of America, which it has its own court system. It has its own prosecutors. It has its own criminal code. And you can be found, you can be charged on a federal level and go to a federal court in front of a U.S. attorney and be convicted there. And you can also violate a state law and have a district attorney put you on trial for the exact same thing and convict you. Why can you do that? And why is that not double jeopardy? Because it's being put twice in jeopardy by the same sovereignty is the problem. These are different sovereignties. We have a concept which we call the dual sovereignty doctrine, where sometimes in some rare instances, very rare, by the way, you don't see this happening all that often. Rare instances, you will have a person charged with crimes arising from the same course of conduct by two different jurisdictions. Usually you'll see this in, like, let's say a drug trafficking case. Perhaps the person was arrested in a state for drug sales and possession, but that person also transported those same drugs interstate. So you'll have the feds come in for that trafficking charge. You'll have the state handling the possession and sales charge. It's still rare, though. You don't see it all that often. Usually, you know, everybody kind of lets everybody play in their own playground. Here, though, they've decided to prosecute him both on the state and federal side. And I'll tell you, the way things are going, it's a good thing they did, because on the state side, it went from a first degree to a second degree because the judge dismissed the terrorism charges, which I'm still surprised that the state attorney, the state DA hasn't appealed that, but they haven't. So he's gone from life without parole to perhaps as little as 15 years. And then on the federal side, it went from being a death penalty case to not. It's now a life case on the federal side because they dismissed the murder charge based upon, I mean, I don't want to get into all the nuances of it, but the judge, and I think the judge made the right decision, but it's just unfortunate. The judge felt that the stalking wasn't a violent crime, and therefore the murder case didn't have a federal hook for a violent crime, and they couldn't charge the murder. They've only charged him with the stalking on the federal side that led to a death. So it gives him a life exposure on the federal side. But yeah, so we're talking different crimes. In fact, they're talking stalking on the federal side, murder on the state side. But yeah, he's going to have two separate prosecutions, two separate judges, two separate juries, two separate trials, because it is a dual sovereignty doctrine, concurrent jurisdiction issue. I feel like I used a lot of words and may have confused all of us, but I hope that makes sense. Oh my Tosh, and thank you so much for calling in from Dublin, Ireland. I think these are both set to go this year, by the way. Later on this year, I think they're both set for trial. So we'll keep an eye on that one. All right. Am I on track? I think I am. I think I'm doing good with my time here. All right, here we go.
Hi, Josh. This is Intuitive Karen. I am from Morrisville, Pennsylvania, and I have more of a law question rather than a case question. I keep hearing often this is probative versus prejudicial or something like that. I don't know if I have a mental block, which very well may be the case. I've heard it explained many times, but I just can't seem to figure out what that means. So if you could explain it to me like I'm 5, maybe, just maybe, I can get it to stick this time. Thanks for all you do, and happy Sunday fun day. Love you all.
Karen from Murraysville, Pennsylvania. Thank you so much for calling in. Karen, I will do my best to explain this to you as if you were 5, but I will say this. I have a 5-year-old, and I feel like I can't explain anything to her, and she refuses to listen to me anyways, but I'll still do my best. Good question, though. This is one of those things where we throw these terms around a lot. We take for granted that people might understand them. But it's a very important part of a lot of what a judge does is make this exact decision. A lot of the decisions about the admissibility of evidence come down to this central question: probative versus prejudicial value. So let's break it down. Probative. Probative means, is it relevant and is it useful? First of all, relevance. Everything has to be relevant. You can't bring in stuff if it doesn't somehow move the ball forward. And you can't bring it in, though it might have some relevance, if it's not helpful, useful to helping the jurors to understand the central question in front of them, which is guilty or not guilty. Is this helping them get to the point of deciding this person's guilt beyond a reasonable doubt? First question, probative. Now, probative might include a lot of stuff, right? It also might include stuff that we would consider prejudicial. So prejudicial means, does it have some sort of inherent bias to it? Does it invoke some sort of emotional outrage? What might this be? I think the easiest example is perhaps very graphic photographs, okay? So you're dealing with a murder case. And let's say that part of that murder involved an incredibly graphic murder scene. Now, is that probative? Sure. It's the evidence. It's the murder scene. What could be more useful and relevant to the question of murder than the actual scene itself and the body itself and the body and how the body was murdered? But if we're talking about a scene that is so bloody and so graphic, is it going to stir up emotions and outrage and anger and bias on the part of the jury? Now, sometimes it can be both, right? In the case of these photographs, it is both, and the judge has to weigh it. Just because it carries some prejudice doesn't mean it's not coming in. And just because it carries some probative value doesn't mean it is coming in. The judge has to weigh it. And if the prejudicial value of it, if the prejudice of it, if the outrage of it outweighs the probative value of it, the judge likely won't let it in. But he'll do the opposite if it's the other way around, or she'll do the opposite. If it has a strong probative value and a limited prejudicial bias to it, they'll allow it in. This is the balancing that has to take place on nearly every single piece of evidence. Many times, too, you'll see a judge deferring to not allowing things in if they have a prejudicial value. Why? Because this could become an issue on appeal. If you are at all setting up a trial where it may look like jurors are basing their decision on outrage, on emotion, on anything but the evidence itself, that could be a problem. Could you still present that murder case without having those graphic photos? You likely could. Could you do it through diagram? I mean, here's a clear example. I have never, only in maybe one instance that's coming to my mind have I ever introduced in a prosecution autopsy photos. Maybe you'll have some photos of the scene, but the actual autopsy photos, never. Not never, maybe once I've done it because it had a different kind of probative value to it. But those are very graphic. I mean, you've got the body and it's opened up and it's just horrific looking stuff. Does it have a probative value? Sure. Is it helping them to understand the murder and how it took place? Perhaps. The cause of death, the stabbing, the shooting, whatever it is. But it's also just seen as being so greatly prejudicial that we don't allow it in. So we use the diagrams. You've all seen those, you know, the outline of the body, and they'll draw where the injuries took place. We use that instead. So yeah, there's ways of introducing this evidence, and just some things are seen, though they are probative, though they are helpful, though they are relevant, as just being too prejudicial for the jury. Great question though, Karen, and I hope that clears things up. Oh, did it? Did I do it on the 5-year-old level? I hope so. Race and Rodeo, thank you so much for the super sticker. Appreciate you. Allie Foley, Kim K passed the baby bar on her 4th try. Well, good for Kim. Bad news for Kim. She's still got to take the big boy bar if she wants to become a lawyer. If you're having trouble with the baby bar, you're having trouble. Court Dog Daniel, thank you so much for supporting the mods with coffees. Appreciate you. All right. Where are we off to? We're fueling up the jet. Where are we off to next? Anybody want to guess? You're never going to get it.
Hi, Josh, Kaylin, Tiffany, and CC crew. This is Karen from China, Jinan in China. Second time sending a message, but barely ever watching live because of time differences. So when you do this, it is midnight in China, and I need to get my beauty sleep in before I get to work. So here's my question. It's about the Lynette and Brian Hooker case. So let's say he did this murder, he hid the body, and his motive was to claim life insurance on her. I don't know if there was life insurance. I'm just thinking about it. How would he ever claim the money? There's no body. He's hidden the body. Wouldn't it be better to make it look like an accident, have them discover the body, rule it her death an accident, and then he can ka-ching, get all the money out? Or would he have to wait 7 years or whatever until she's legally declared dead, and then he can ka-ching, get the money out? Or is he just a big loser? Thank you.
Karen from Jinan. I know I'm not saying that right. Jinan, China. That's right, everybody. You heard it. Courtroom Confidential is in China. China, that's wild, says therapist. You know, it is wild. And it is now on the Courtroom Confidential 2027 World Tour. Thank you so much, Karen. This is a great question. Talking about Lynette and Brian Hooker. Lynette, still, her body has never been discovered. By the way, that is probably the single most suspicious thing about all of this now, is that her body has still not washed up, which my understanding is that they've said the people who live in those local waters say, yeah, sometimes this happens. People go overboard. Their bodies always wash up within a day or two. Her body has never been found. That either means to me it was weighed down or it never went into the ocean there. So great question, Karen. And you're asking about life insurance. If he was doing this for the life insurance, and again, he's never been charged. They are investigating. I don't think he's even currently considered a suspect, at least not officially by anyone, or a person of interest. If this is a case where she simply went overboard and it's a tragedy, I would feel awful for dragging this man through the mud. But there's a lot of questions that I think are worth asking here. One of those is, if there was foul play, and if it was for insurance money, is this a smart move to make her disappear, or is the smarter move to have her body, quote unquote, discovered somewhere so you can get the insurance money? Well, a lot of this is out of my pay grade, I guess it is. But you know what? Though I may be what would I say? I'm never stumped. I don't know. I can always phone a friend.
Thank you for the question, all the way from China. And while, if we assume that he did murder his wife, we can certainly be critical of murder. It is rarely the answer. We can't be too critical of his strategy of throwing her off into the ocean. As residents of Michigan, it's going to take him maybe an extra 63 days to have her established dead, and then the insurance company is going to have to pay out that life insurance in a couple of months. So while it does add a little bit of complexity to collecting life insurance, it's certainly not a huge obstacle. You weigh that against the body, which is going to be evidence, and who knows what that tells law enforcement. So again, murder, not a good call. Throwing a dead body over the ocean, probably the right call. All right, keep watching and listening.
There's my good friend, former colleague from the prosecutor's office, David Gammill. He's now a civil attorney here in Southern California. There's his Instagram and his website. Please check him out. Tell him hello and thank you from all of us. Send him some juice boxes just to thoroughly confuse him. I will clarify and say that David is very carefully not advocating for murder or for hiding bodies. But he is saying that if strategically that was what he was trying to do, might not have been awful. I was shocked by that, how quickly you can have a person declared dead and collect on the life insurance. I thought the same thing. I thought it was a matter of years. Sounds like not so much. It's a matter of getting a birth or a death certificate, pardon me. And apparently in Michigan, that can be done within a matter of months. So, yeah. And by the way, there's nothing legally preventing that from happening right now, because he is not a suspect. He has not been arrested. He is a free, uncharged person, and therefore and by the way, the rightful, as things stand right now, the rightful beneficiary of her life insurance, by the way. If he's in fact on her life insurance and the beneficiary, the life insurance companies legally have to pay him. It's not a matter of, well, we're going to see how things play out here. They legally have to pay him out, or they're in trouble themselves. So it's a wild situation that he could be collecting on that within a matter of months. Again, I want to see this come to some sort of conclusion as well. If that is an arrest made, so be it. If that is some sort of exoneration, so be it. But the fact that we still don't know what happened to this poor woman is unacceptable to me, and I hope they get to some sort of conclusion on that. All right, let's keep it rolling here. First of all, let me thank Mary Swampy. Thank you so much for supporting the mods with coffees. That's very kind of you. Beth Ringle, do you think the judge is just being thorough due to the scrutiny? I think you're talking about the Tyler Robinson case. I think he is. And so I was giving him a lot of latitude. And listen, I'm not trying to say like I'm some sort of, he's a judge. I'm not. I'm some jerk on YouTube. So I'm not trying to say like I know better than him. But for a lot of this, I was without criticism because I thought, listen, it's a very important case. It's a death penalty case. He's going to give some deference to the defense. No reason to do this quickly. There's only a reason to do this the right way. But now it does seem like things are getting a little out of hand with how much time is being taken on this. So thank you, Beth Ringle, for that. And Helen, the Scottish Llama, everybody. Thank you so much for gifting the membership. Appreciate you, Helen. All right. We landed in China. Where are we flying to next? I don't know, Ritter, but you better find the next question here. Here we go.
Hi there, CC crew. Mandy here, sitting in my tiny cottage in a tiny harbour town in County Wexford, Ireland, suffering whiplash from vigorous head shakings because Gerhardt Konig, him, is now asking for a retrial as well due to serious juror misconduct, no less. So between Gerhardt and that stupid Becky, my voodoo doll stash is headed for an all-time low. Now I need maybe 4 of them. 1 for Becky, 1 for Gerhardt, and at least 2 for jurors who apparently made really bad decisions and then couldn't shut up about it after. So not that any of us agreed with their verdict, but now what is the story with double jeopardy if he does indeed get a new trial? And can we really put up with him droning on and on and on about his testicles again? Like, seriously. Look, considering this, I may have to request a CC Crew fundraiser for feral cat treatments because, honestly, I don't think I can do this again, or I may be broke for centuries. How about for a small donation, you too can have a voodoo doll, or 5. Yeah, even throw in some needles if you're up for a bit of a supernatural revenge. Wow, just kidding. Look, happy Sunday fun day, guys. Be kind to each other and enjoy CrimeCon, okay? Slán go fóill.
Mandy from County Wexford, Ireland. Thank you so much. First of all, we do not condone any kind of violence here on Courtroom Confidential, even if it is against voodoo dolls. But what I don't know won't hurt me. So go right ahead and do whatever you feel like is going to help you with some sort of cathartic moment here. You're right. I have not. I followed. There's just a few articles reporting on this, but May 15th, Thomas Otake, who is his lawyer, Gerhardt's lawyer, did file for a new trial based upon some comments made by the jury. And if you remember, this was a bit of a bizarre verdict in this case because they convicted him for an attempted manslaughter, which already has some kind of problematic stuff built into it, because the difference between manslaughter and murder is intent. We talked about this earlier. It's what were you thinking? What were you intending? What was between your two ears? Not what you did. What you did was bash a rock against your wife's head. Okay? That doesn't change whether it's murder or manslaughter. It's what were you intending? And manslaughter requires some sort of lack of intent to kill. Perhaps it's an intent, heat of the passion, intent to cause some sort of great bodily harm, but you're bashing somebody's head here. So the fact that they said that he attempted to not kill her but harm her, I don't know. I mean, as I'm kind of speaking through it, I already find myself being more confused by it. It was a bizarre verdict. Well, then to add to those troubles, the jurors spoke. And I don't know if this was just to the defense in interviews or through media, but they made comments that there were some of them who questioned his intent to kill. Here's the problem. The intent, as I said, is the distinguishing issue between murder or attempt murder and attempt manslaughter. If they can't agree on it, then they should have come back as hung. But it sounds like what they did is because some of them couldn't wrap their heads around the attempt, the intent, the ones who did think it was intent to kill just said, well, okay, we'll just make it an intent for a manslaughter. In other words, they compromised. It was a split baby sort of decision. It sounds like some of the jurors were back there saying, well, okay, I don't agree with you. I think he did intend to kill her, but I'll go ahead and agree to this verdict. That is not the way it should work. In other words, you have to acquit of that greater intent before you move down to the lesser intent. And it sounds like they didn't do that. And his attorneys are saying that's an improper verdict, and therefore we're asking for a new trial. Now, the problem with this is be careful what you ask for, because you're not going to get yourself an acquittal out of this. I'm saying from the appellate court. If you are victorious, what you're going to get you're not going to get less than manslaughter. In other words, it doesn't sound like they had a disagreement that it was something less than manslaughter. It sounds like they may have had a disagreement on whether or not it was an attempt murder. What are you asking for? A new trial? Good luck, buddy. I don't think things are going to get better for you. I am there. Sometimes there's a little bit of don't kick the bear thinking that needs to take place sometimes. Maybe you have an argument here to be made, but should you be making that argument? And like I said, please spare us all, or like Mandy said, please spare us all more discussion of your testicles. We've had enough, sir, for this and the next lifetime. All right. Let's keep it rolling here. Oh boy. It's that time, everybody. Get out the hankies. It's time for the final three questions. Oop, oop, oop. You can't hear that, can you? Hold on.
Hello, Joshua, Tiffany, Mods, CC Crew, Kaylin. I ain't forget about you either. Good morning. This is Nashay, aka Mixed Firebird's child. I have a question about juries. Is it good? Is it good practice before your call for jury duty, to lock down your social media accounts, or is that just a is that just a myth or whatever? I'm asking because you can tell a lot from a person from their public social media accounts. Is that a way that jurors are eliminated from the potential jury pool? I Googled about AI in the use of it, being used to scrape people's social media accounts to choose them for a jury pool, but that seems to the consensus that I read is that can add bias. That can add its own bias. What are your thoughts? All right. Have a good day, everybody. Bye.
Nishay, good to hear from you from Philadelphia, Pennsylvania. Hey, it's me from the past. Yeah. It's your past self talking to you in the future. I like this question a lot. Is it a good practice to shut down or scrub your social media accounts before you're going to go for potential jury duty? Actually, I don't think it's a bad idea. I think if you're going to go report for jury duty and you don't want your personal business kind of dug through, just making your accounts private is not a horrible idea. I don't think you need to go through to the point of like removing things. That all being said, this does not happen nearly as much as you might think it does. In my entire career as a DA, we never looked through anybody's social media. Part of that was social media was not as big a deal as it is now when I was practicing. But part of that too is we just don't have the time and resources to do all of that. You've got, hundreds of people coming in for potential jury duty, even on a big case. You're going to get the time to try to search, Google search, find social media on all these people. Now, doesn't mean it doesn't happen. And in fact, in some larger civil cases, it probably happens more often in the criminal cases. They've got the money and resources and attorneys and law clerks and everybody else to start searching through people's social media. And I've heard of instances where that is being done. But, in your average criminal case, you walk in and the attorneys are finding out who you are minutes before you walked in there, if they have your name at all. And then they question you for they get 20 minutes to question 60 different jurors. They just do not have the time and resources to be digging through people's social media. But on a larger criminal case, some big, huge, media attention case, maybe the defense is spending some time trying to figure out who these people are. But most often not. But in the off chance that they are, and you don't want your business being searched through, shutting it down ain't a bad idea. Also, I would say if you get picked for a big case, if for some reason, Nishay, you are on Alec Murdaugh's retrial, keep it private and probably keep it private for a while because it's not even during, it's the after as well that you don't want people kind of trying to search down who you are. But yeah, we live in a funny world. A lot of access to who we are out there. Just be cognizant of that in your day-to-day life at all. Applying for a job, doing anything. It seems like people are rushing to find out who you are online as well. Great question. Appreciate you. All right. Let me get to our next question here.
Happy Sunday, Joshua, Tiffany, Kaylin, Fabulous Mod, CC family and guests, Alicia K. Mayo in Humboldt, Tennessee. All right, Joshua, I was watching another YouTube channel that shan't be named early the other morning, And they brought up Michael Hernandez of Florida, who at the age of 14, shall we say, poked a friend of his with a sharp object until he was no longer on this mortal coil. And young Michael was given a mandatory life sentence. Then when the Supreme Court came down with their ruling years ago, he was found guilty again and sentenced to life in prison. He has since passed away of natural causes. I guess I've been confused this entire time. So a person under the age of 18 can be sentenced to life. They just can't be sentenced under mandatory statutes. Is that correct, or am I completely confused all over again? All right, Joshua, looking forward to seeing y'all on Box Nation at CrimeCon. Hope y'all win. You're a winner regardless in my book. And everyone, hope you have a great Sunday Funday. Bye.
AKM from Humboldt, Tennessee. You always put a smile on my face. Thank you so much. Great question. I'm glad that you asked this because it does give us an opportunity to discuss something that we've talked about before, but we kind of breeze by. So Michael Hernandez, horrible case, stabbed to death his friend back in February of 2004. They were both 14 years old at the time. 14-year-old committing this type of a murder is just wild to me. And he was sentenced to life without parole at the time. That was back, like I said, back in 2004. In 2012, the Supreme Court, in a decision called Miller versus Alabama, came out and said, not that a minor, a person under the age of 18, could never be sentenced to life without parole, but only that they couldn't be sentenced to a mandatory life without parole without a special finding. So it is more nuanced than we say. We like to say they have said that the death penalty for minors is cruel and unusual punishment and therefore runs adverse to the Eighth Amendment. Okay. But they haven't said that life without parole is a full stop cruel and unusual punishment. But what they have said is that a mandatory, so in cases, say it was a special circumstance case, or as we would call it here in California, aggravated murder in Florida, if that person is above the age of 18, they're convicted of the first degree murder and the aggravating circumstances, it becomes a mandatory life without parole with the potential of the death penalty. They're saying that mandatory part is the problem. What they're now saying needs to happen is that in the rarest of circumstances, you need to make some sort of special finding. And what that finding has to do, if you're going to ask for life without parole, a determinate sentence, meaning they don't get the chance of parole at all. If you're going to ask for that, you have to have a finding from the court that that young person is permanently incorrigible. No chance at rehabilitation. Tell me if you think that's likely to happen. How is a person at the age of 14, 15, 16, 17 going to demonstrate to the court that they are permanent incorrigibility? Likely not to happen. Doesn't mean that it's impossible and doesn't mean that it's a flat out prohibition, but it just means incredibly unlikely. And so that's why we talk about it in the way that we do, that you just don't see these types of sentences with people under the age of 18 anymore. They're usually sentenced to life, but with parole eligibility after 25, 50 years, whatever it is. Great question though, AKM. I'm glad that you asked it so that we could kind of get into the weeds on that. Horrible case though. Johnny Knoxville says the Soulmate has been renamed the Cellmate. Very clever. That's the name of the ship that the hookers had. I just cannot get over the irony of the name of the ship is the Soulmate and Now everybody believes he may have killed her. It'd be like naming the boat, "I'll never throw you overboard." The name of the boat is "You're never going overboard, sweetheart." Allie Foley, thank you so much, says, always review your beneficiaries yearly on your policies, especially ones through work. I've seen some ugly situations over the years because people didn't. Is that where, like, they've changed who they want the money going to? Is that what you're talking about? That's interesting. I got to check who my beneficiaries are, because my wife sure is on top of making sure I pay for that life insurance every year. I got a sneaking suspicion too. There's more life insurance out there on me than I originally thought. She's oftentimes grabbing a kitchen knife and giving me side eye. Thank you, Heather Cooper Smith, for the super sticker. That's very kind of you. Appreciate you. All right. It's our last question, everybody. Who's bringing us home today? Who's closing us out for the week? The last one before CrimeCon.
Sup, y'all? Court Dog Daniel here. Josh, tonight I was listening to previously sealed pretrial hearing transcripts from the Donna Adelson case involving allegations that Donna expressed an interest in putting a hit on Catherine McBanoa before trial. It was from a very late investigation that produced evidence that was presented only 1 month before trial. And aside from how wild the hearing itself was, I was struck by how incredibly brilliant the attorneys Zellman and Kappelman were, but especially Judge Stephen Everett. And it made me realize I've never asked you this before. After spending years around brilliant attorneys, legal scholars, and judges, what do you think separates the people who actually become judges from the lawyers who don't? At the state trial court level especially, what qualities, or maybe even politics, tend to determine who actually gets the robe? See y'all in 5 days at CrimeCon. I'm so very juiced. Just kidding. Juice!
Court Dog Daniel, CDD from New Britain, Connecticut. Always juiced. Thank you so much, my friend. Yes, that's our last Sunday fun day before CrimeCon. We're all running at max juicery. Great question too. What I thought at first you were asking, like, what makes a good judge, but I think you're more asking, how do people become judges? Like, what is the secret sauce that makes them become a judge? And yes, I agree with you. Judge Everett is about as good as they get. And I think why he's so good is he displays both of those qualities that you want in a judge, which doesn't necessarily mean that's how he became a judge, but thank God he did. There's two things I think that are very important in a judge, and that's one, being good on the law, and two, having a good temperament. And if you've got both of those, you've got a unicorn. If you have neither one of those, you've got an awful judge. And if you've only got one of those, you're doing okay, but you're still struggling. If you've got a judge who's got a great temperament but bad on the law, I'm sorry, you're going to have a good time all the way to the crazy house. If you've got a judge with a bad temperament and good on the law, I'll take that any day of the week. I don't mind getting yelled at as long as you come out with the right decision at the end of the day. But a judge who is both good on the law and has a great temperament is like I said, a unicorn. And they are not as common as you would hope. But how does a judge become a judge? Well, in California, like many places, there's two ways. One, the governor can appoint judges, and that is a political decision. It depends on the governor and what are they looking to do. Are they looking to advertise their diverse bona fides? Are they looking to put on the bench people of certain backgrounds and ethnicities, and to promote that quality that they're hoping to pursue in the bench. Not that there's anything wrong with that. There's fantastic aspects of having a very diverse bench. But I think a lot of judges are making decisions based upon, or governors, pardon me, are making decisions based upon that. Or politically, are they looking for people who have a background in prosecution and kind of heavy on law enforcement? Are they looking for people who have a background in, criminal defense and might be more lean that way politically? They also appoint civil judges, by the way, too. Many judges never see a criminal case their entire life. I think there's far more civil judges, I think, than criminal judges even. So that's one way. Or the other way is you run for it. And then it's kind of up, it's like any other political election. Who raised the most money? Who got the most yard signs out there? Who's got the most name recognition? I mean, there's a lot of you'd be surprised too how much goes into the designation on the ballot. When it says like Joshua Ritter, former prosecutor, there will be people who litigate and sue the other the other people running for that position, saying that's an improper delegate or improper designation. There was somebody not too long ago who put on their designation, it was something like gang prosecutor, and they had to remove it because they got sued by one of the other people running because they hadn't actually prosecuted a gang case in like a decade or something. It was, I don't know. People get really weird about this. How the clever ways because sometimes people, especially for judges, nobody knows who these people are. So they're just looking at the designation. Oh, that guy was a former prosecutor. I'll vote for them. Anyhow. Hope that answers your question, CDD. But most importantly, you are right. CrimeCon is just a mere few days away, and we are all fully juiced for it. So let's get to our announcements and then get you guys out of here. Thank you so much, Songbits Laura, for the super sticker. CrimeCon spending money. Maybe we need to teach you first again. No weapons nowadays. Fist first, no weapon. Yeah. Wouldn't we all be happier if there was just a bunch of people out there, handing out knuckle sandwiches rather than shooting and killing each other? Ali Foley, thank you, says, I've seen an ex get all the money and the current wife and kids get nothing. They hadn't been married in 15 years. Incredible. I got to check my life insurance. If only Tiffany wouldn't hide those documents from me. Why does she have a safe just for herself with the documents inside of it that I'm not allowed the combination to? Kim Schmidt, thank you so much for gifting the memberships. That's very kind of you. Appreciate you. All right. Let me tell you about the courtroomconfidential.com. It's a website that we have. If you have listened to these questions today and you said, those are fantastic, I want to ask my own, you need to go to thecourtroomconfidential.com and click on leave a message. And that's where you can leave a message to ask a question about a true crime case, about the law, about any of the stuff that you've heard us talk about today, and we will answer it for you live at the next Sunday Fun Day. Membership. A lot of you received memberships. A lot of you gifted memberships. Appreciate that. If you didn't receive one, don't get discouraged. You can go to thecourtroomconfidential.com and click on Become a Member and find out about all of the benefits of membership. And we put a lot of work into that. And then finally, merch. If you're looking for a new t-shirt, if you like the color that I'm wearing today, if you like any of the other variety of colors that we have available to you, plus quarter zips, plus full zips, plus hoodies, plus tumblers, notebooks and hats and pajama pants and hats again, we've got you covered over at thecourtroomconfidential.com. Please check out the shop, including new CrimeCon t-shirts. So if you still haven't picked yours up before CrimeCon, please do that. Stay tuned. Oh, pardon me. What did you, there it is. There it is. So proud of this. Again, every time I see this, I'm impressed by what, this is all Kaylin, by the way, guys. She put this all together and I'm just so proud of how it looks. What did you miss? Well, we had our weekly roundup on Friday. Don't forget your passport. Why would I do that? We had a weekly roundup on Friday. We talked about Ebony Parker, a little bit of Gregory Moore, Larry Miliette. Please check that out. It's up on our channel now. Stay tuned. Monday, we are going to have our Monday night special. It will be at the same time, 5 p.m. Pacific, 8 p.m. Eastern. And our special guest is going to be Paul Morrow. I'm excited to have Paul on because I love chatting with him. He's brilliant and he's hilarious. And he's also one of my co-hosts for the weekly rap sheet. And we're all going to Vegas together. So we're going to kind of do a little bit of a preview for Vegas. And we're going to be on a panel together and doing some other special stuff out there for Fox Nation. So I want you all to get a chance to meet Paul if you haven't already, tomorrow night, 5 p.m. Pacific, 8 p.m. Eastern. Then Wednesday, there's a time change. We're doing it a little bit earlier at 4 p.m. Pacific, 7 p.m. Eastern, because I got to hop on a plane to go to Vegas. So please join us on Wednesday, 4 p.m. Pacific, 7 p.m. Eastern. Why are we talking about all of this? Well, CrimeCon is coming up. It is this Thursday, starting Thursday, right? I think Thursday's like early something or other. I don't know. Everybody's yelling at me. Anyhow, it's 29th through the 31st. I guess it's officially Friday through Sunday, but I guess they're doing some, I don't know, early stuff on Thursday. Anyhow, it's in Vegas. There are still one-day passes available. You can get 10% off by entering the word courtroom, all in caps, all one word. We have a shirt. I've already mentioned the shirt. We've got it in black. We've also got it in white. A lot of you cleverly suggested white so that maybe you could pick up some signatures, some autographs while you're out there. It's available now for everybody on the website. By the way, you can wear this from home while you watch CrimeCon on Fox Nation. If you're not able to make it in person, you can still have a shirt. I will be on a panel along with Paul Morrow and Donna Rotuno and Mike Ruiz on Friday at 3 to 4. Please join us if you're going to be out there. Would love to see you all. Would love to have that support. Would love to have you screaming your heads off as we talk about the latest on the Nancy Guthrie case. And we're going to be doing a meet and greet afterwards. So I hope to meet as many of you as possible. Thank you, Lee Hillard, for being a member for 5 months. Appreciate you. Happy Crewversary. And one last thing about CrimeCon. I am very honored. We are touched. We are beside ourselves with your support because we have been one of the folks nominated for the People's Choice Creator of the Year Award. So if you are going to CrimeCon, we would love to have your support on that as well for the Clue Awards, which will be on what, Saturday evening? Is that when they are? Okay. And that's it from us, everybody. Thank you all so much for being here. Thank you for carving out some time on a Sunday. Big shout out and thank you to David Gammill for being our phone a friend this week. Thank you so much, Janet Cameron, for becoming a YouTube member. Appreciate you, Janet. Please follow David on his socials. Big shout out and thank you to Afton, Sonia, Kathy, Therapist You Know, and Best Nancy for being the best mod squad on YouTube. Kaylin, you're fantastic. Thank you for everything. Thank you for designing the shirt. Please send mom and dad a special thank you for their membership. I appreciate their support. And Tiffany, you are the best thing that ever happened to me. We will see you all here tomorrow night. Take care, everybody. Bye.